Good morning. I hope everyone had a great holiday weekend. I see everybody survived the Arctic freeze the last few days, which I understand we have more to come. All right, so, pardon me?
Barely.
You barely? Oh, no. I always think of that movie Armageddon, where there's that scene and everybody's just like had frozen in place. So that's like my analogy is it's so cold that I feel I'm going to go outside and just freeze in place. Well, welcome everybody. Today is Tuesday, January 20th. We have, let me count. We have 8 cases on the docket this morning. 3 are being consolidated for the purposes of argument this morning. And those 3 are the first that I will be calling out. Several of the cases have also submitted onto briefs. But for those that are being argued this morning, if attorneys can please identify themselves and their readiness to proceed, all right? Can everyone hear me? All right, okay. All right, so the cases that are consolidated this morning are C250067, C250069, C250276, Sherry Puckett Morissette versus Durrani, Darrell Reynolds versus Durrani, Cheryl Wyatt versus Durrani.
Good morning, Your Honor. Aaron Herzig and Philip Williamson for appellants ready to proceed.
Good morning.
Alan Snapman and Ben Moran for the appellees ready.
Okay, good morning.
Thank you.
And I know that there was subsequently a motion to suppress that was filed, not a motion to suppress, a motion to supplement that was filed. Are both sides still at 15 minutes? Are you both looking at 15 minutes each?
Yes, Your Honor. In fact, I intend to spend most of the time on that new issue.
Okay, all righty, thank you. All right, the next case we have is case number C250296, Anna Frances Dove versus CMHA. If attorneys can identify themselves and their readiness to proceed.
Jeff Pando for the appellant.
Good morning.
Elizabeth Ajani for the appellee Dove, and I'm ready for
Okay. Thank you. All right, the next one we have is C250312, N-Ray C.R., and this case is also being argued this morning. Good morning.
Good morning, Your Honor. Brad Berry on behalf of the appellees.
All right, thank you so much. So the remaining of the cases are all submitted on the briefs. They are case number C250607, In-Ray LD and HD, C250289, State of Ohio versus Michael Jackson, and C250142, State of Ohio versus Shanten Kirkland. All right, good morning. Attorney Herzig, I understand that you're arguing this morning?
I am.
Okay.
I'd like to reserve 5 minutes for rebuttal, if I may.
I'm ready.
May it please the court, we have a new issue in this case, which is the effect of appellants' attempt to no longer defend the fraud claim in this action. They've done that in a number of other actions. Let me level
I
set.
think we have 2 pieces to that, if you don't mind. One is our authority and then the other is if we have the authority, the effect.
Absolutely. So this court already denied, there are 2 pieces to what appellees filed. First was a motion to dismiss, which of course an appellee couldn't do. Wouldn't it be nice if appellees could just come up here and dismiss appeals and win? You denied that properly in all of the cases in which it was filed. The second piece was that they said they no longer challenged the appeal as it relates to the fraud claim. I think in order for you to have authority, you have to interpret what they really mean, and I'll be interested to hear what they really mean. In our view, it is first of all a confession of error. What they're really saying is we wish we had never brought the fraud claim in the first place, and a confession of error, in our view in this case, would lead to judgment for our clients.
Well, I don't know if it's a confession of error because then if it's seen as such as that, the way I'm interpreting what you're saying is that if it is that level of a confession of error, then it's also a frivolous claim. And that opens up to other motions to come thereafter.
Your Honor, we have no other bucket that we know how to put this in.
Okay.
So the best we can come up with is something like a confession. We haven't seen this before, I don't think.
I mean,
this
it could be
court has.
a waiver for the arguments that, so,
It could, but then you're leaving them with a fraud claim that they don't want anymore. We don't want it anymore.
Well, what is the effect then of our denial of the motion? We've denied the motion, so theoretically, they are charged with defending the entirety of what happened below.
If you don't want to give appellees what they want, you don't have to. I agree with that. We brought to this court's attention our view that what they asked for was one of two things. Either dismiss the claim, or they're letting you know they no longer defend. We asked you to consider the idea that the motion has two pieces. If this court disagrees and just says we've denied the motion, period, that's fine. But to me, the question is, how do you give appellees what they want?
well, and that, I want to talk about authority, because, we're getting down to like, these are the options, this is what it means, let's interpret this, but do we even have the authority to entertain what's being requested?
It is, I think, unclear, but we would say yes, because we do think if appellees want to give up a verdict below, we would agree with that. We would, if they wanted to enter judgment for defendants, that's a dismissal we would agree to. The dismissal rule in the Court of Appeals, as you know, is Rule 28. It talks about dismissing a proceeding, and it only gives the appellant, of course, sorry, me, the appellant, the right to do those things. So there isn't a rule. They don't cite one. There isn't a rule.
Which comes back to the authority.
That
Because our authority
yes.
is also, it's to affirm, it's to reverse, right? And so I don't, and so if the appellant wants to dismiss the appeal, then we certainly have the authority to grant that dismissal.
Right.
But what we're being asked, where does it fit?
I agree. It is a difficult question. Again, I come back to the appellee has said to you, they don't want the fraud claims in their case anymore. I think there are only two ways to accomplish that. One, in my view, the first one, the one that's best for my client, is dismiss and enter judgment for my client. The other would be to remand for a new trial without the fraud claims. Because as you all have held time and again,
Well, but
the
they're
fraud
the,
claims
they're
are-
the appellee, so I don't know that we would dismiss and enter judgment for your client when the appellee is making the request.
If they no longer want to defend their case, then
And we would
What-
determine it on your brief.
why? Why would the court do that for these appellees?
Because that's what
that
the
it
appellate
doesn't do
rules
for
tells
them?
us to do. If they never showed up for their case, we would determine the case on your appeal. Why would we do any different if they're saying dismiss their case?
You certainly can do their work for them. I don't think that's what this court typically does. It typically puts the appellee through its
That's
paces.
not doing their work
And-
for them,
and-
Attorney Herzig.
Oh,
The appellate rule says if the appellee doesn't, it addresses if the appellant doesn't file a brief, and it addresses if the appellee doesn't file a brief. And it never says that we are to become advocates and do their work for them.
Well, in order, what they require in these cases is they don't cite the record in our appeals. They don't cite the proper record in our appeals. They demand of you and your staff to go through and do all of that work for them. And the rules do say they have to assign errors, they have to cite the record, they have to cite law. So that's what I mean, Your Honor. Colloquially, you end up doing their work
Understood.
for them.
Well, we have two options. One option is to invoke the appellate rules and say you didn't cite to the record. That's
Which
one
we
option,
advocate in other
right?
briefs, absolutely.
Okay.
We've made that very clear lately. We've also started to move to strike briefs that are non-responsive or require this court to colloquially do their work for them. But how do you give appellees what they want here? You may not be able to. That's fine, but then they have told you affirmatively they don't want the fraud claims anymore. I think it is a challenge to figure out how you give them what they want. And to me, the other answer besides just entering judgment for us, because they're not defending anymore, would be to remand for a new trial without the fraud claims and the fraud evidence. This court has said since Adams, if not before, in paragraph 83, that the fraud and the negligence are all intertwined and cannot be disaggregated, and has even said that if we asked for instructions disaggregating the damages, it was not error for the trial court not to grant that. In this case, all of the damages are aggregated. There is one damage award. The punitive damages, as we cite in our supplemental brief, the jury specifically wrote deceit, or in one case, malice, trickery, and deceit. These are fraud cases. That is the underpinning of consolidation in these cases, is that our client committed fraud, and therefore all of the torts flow from the fraud. They no longer want the fraud claim. You have said you can't disentangle those things, so the only answer is remand for a new trial without the fraud. The only answer, other than confession of error, is remand for a new trial without the fraud. And in this case, they would have to be separated, because they did not make this motion in Reynolds. Reynolds sits before you as any other prior Durrani case. But Puckett, Morissette, and Wyatt, they did. And so in order to give them what they want, our view is you either end the case here with a judgment for us, or remand for a new trial. And no, we couldn't come up with some other option. They don't offer one. I will make a few notes about their supplement. Their supplement they filed on Friday claims that we did not serve them. As the kids say, I literally have the receipts. If the court needs those for evidence, we can provide them, but we have the read receipts because, unfortunately, Appellee's Counsel has done this before, and we've had to go through affidavits and the like to prove that we, in fact, serve them in other courts. That is not true, what they said there. We asked them to correct that before our argument this morning. They chose not to. They say in their brief that they can drop a claim at any time. They cite no rule for that proposition. We know of none. I think Your Honor is correct. There isn't one. They cite Clark in the Ohio Supreme Court, where the Ohio Supreme Court granted the motion to dismiss the fraud claim. In the very same announcement, literally the next paragraph down, or maybe the paragraph above, they deny, actually in the paragraph, just below, they denied the motion to dismiss the fraud claim. And just this morning, we've learned that they denied the motion to dismiss in Fenner. So I don't know what weight to give what the Supreme Court did, but it was an unreasoned decision. It just was an announcement. We don't think that has any weight.
It's interesting about the Supreme Court, what they did, because what was the difference between the two cases, other than the panel members?
We are confused, and we are going to be
Yeah,
addressing
it was a one
that
justice
now.
difference, as I understand.
And to your point, when they haven't, this is on jurisdictional petitions, so they have not accepted jurisdiction and are granting or denying motions.
Yeah, so that's.
It's confusing to us as well.
It's confusing even on authority on how the Supreme Court denies the writ of jurisdiction, but then grants the dismissal.
Yeah, so from our view, you would give that no weight at all. And if you're going to count, well, there are two in one on our side and one on theirs, so now you would weigh it in our favor. But we don't think it means anything for what this court does with this issue right now. They also claim that fraud and negligence can be disaggregated, but as I said, this court has already decided it can't. When you look at the jury interrogatories here, they gave one damages award for all of the claims. The punitive damages are based only on the fraud, so you'd have to enter some order to vacate just that portion. But we don't see, the heart of their case is the fraud. I see I'm in my
If you want
time.
to
I'll
wrap
go
up,
for another moment if I may. What they say in all the other cases is that essentially the fraud is the heart of this case. That's why they want to put them together in consolidation. That's why they do these things, because they want to try the man, not the medicine. When you take out the heart, you kill the body. When you take out the fraud, you kill the case.
Okay, well, thank you.
Thank you, Your Honors.
Morning, everybody.
Good morning. How are you doing? How are you doing, Attorney
Oh, I'm
Statman?
sorry, I
That's
couldn't
okay.
hear you. How am
I
doing?
figured.
Well, as
I'll
you were
speak
talking
louder.
about the cold weather, I spent the entire weekend letting my dogs in, letting my dogs out.
Because when they go out, it's kind of difficult when it's
It's
cold.
too cold.
Yeah.
So when I complained about it, my wife told me that, well, now you know what I've been dealing with all winter. So that was most of my I put a dog door in to try to alleviate some of this, but it was too cold to keep the dog door working, so.
Absolutely.
Right,
And I'm
right.
not sure that they were inclined to use it when it's this
Well, I
cold.
taught them, oddly, you shove them through it a couple times
Mm-hmm.
and then they pick it up, but it wouldn't keep the coldest of air out, so it was
Yeah.
freezing all of us. We closed it for the time being.
Absolutely.
But yeah, that was my weekend. And being told no by my 4- and 5-year-old to anything I asked. So there were several interesting points that I just heard that I'd like to address, and certainly I'll answer any of your questions. But whether it's negligence or fraud, the allegation is he did medically unnecessary surgery. And so it's an indivisible injury, whether it's fraud or whether it's negligence. So it's easy to disentangle because the verdict itself on compensatory damages doesn't have to be disentangled. And you can look exactly at the verdict, which is part of the record, and you see, for instance, in I think it's the Puckett verdict. Puckett-Morissette, Dr. Durrani failed to meet the requisite standard of care.
So how does that argument apply to the punitive damages?
Well, the punitive damages are part of the fraud claim, and then they found separately from the breach of the standard of care that there was malice, and they awarded punitive damages. Now, the punitive damage award, it's not shocking that it's the same across all three cases. That's typical because it's the same fraud result with each case, that he did unnecessary surgery, breached the standard of care, and then separately, the instruction for punitive damages is, did he have a reckless disregard for the safety of the patient?
So one of the arguments this morning is with regard to the interrogatory that was filled out by the jury as it relates to the punitive damages. And the language therein that seemed to be reflective of fraud.
Well, they did make a finding of both negligence and fraud in the case. The interrogatory clearly says they made a finding of negligence. They're asked, did Dr. Durrani breach the standard of care? The jury said yes. State how he breached the standard of care. They then fill out the next interrogatory. Was the breach of standard of care the proximate cause of the injury? Yes. What are the resulting damages from the breach of the standard of care? And then, did he give them informed consent? Did he commit a battery? And did he commit fraud? Those are all answered separately in the interrogatories. So there isn't magic about how the jury came to a verdict. It's not 1984 where interrogatories were seldom used and you just got a general verdict with damages based upon everything the court instructed. These verdicts dissect out each step of the way.
Do they dissect out the damage award?
Well, you can't apportion damages between fraud and negligence.
And isn't that the problem?
Well, it's not a problem because it's an indivisible injury based upon the claim. The claim is Dr. Durrani did medically unnecessary surgery.
Isn't that a little bit different than he defrauded people who were coming to him for medical care? Wouldn't the evidence be different in a fraud claim versus what you just said was the
Well, the
med mal?
question for the jury is, was it negligence, was it fraud, or was it both? The
Well, I know, but
jury-
if you theoretically were remanded and you weren't allowed to use the words, for example, fraud or deceit, and you just had a medical malpractice case, which was much more a medical case than a fraud and deceit and misrepresentation case, wouldn't it be a different, potentially a different outcome?
No, we would get the same compensatory award because the award is for the unnecessary surgery, the being taken into the operating room, being cut upon, having scopes, because sometimes it's a minimally invasive surgery. But we've shown the jury through testimony and graphic evidence that it's not so minimally invasive. There's 6 or 7 tubes they put in you to sight where they're going. It's that whole process of what did the negligence cause? It caused an unnecessary surgery and the damage associated with it. What did the fraud cause? The unnecessary surgery and the same damage. You can't say when a case has unnecessary surgery, not did he do the right procedure? Did he do the Smith procedure? And he should have done the Jones procedure. And then you dissect out what part of the injury was caused by Smith that wouldn't be caused by Jones. Unnecessary surgery is an indivisible, compensable injury. And there is no way to say this portion of the damage of $1 million, for instance, was caused only by negligently taking him to an unnecessary surgery versus this part of the damage was caused by fraudulently inducing them into an unnecessary surgery.
But wouldn't the introduction of evidence of fraud pollute the deliberations of the jury? In other words, someone who was likely or did commit fraud is also more likely to not comply with the applicable standard of care. How do we know that didn't occur?
Well, what I know historically in the records that you can take judicial notice of is that not every case there is a finding of fraud, and not every case is fraud even in the case. So some of the cases are straight negligence cases, some of the cases are both, and the jury makes a mixed finding. Sometimes the juries find both negligence and fraud.
The
Sometimes-
fraud was in play in all the cases that are before us this morning, is that right?
I believe that there was fraud introduced in all these cases. But this idea that the fraud is diluting the verdict, I could dismiss fraud before the case actually goes to the jury.
Well, sure. So
So-
that gets back to the authority of like, what do you think our authority is to dismiss at your request
Well, I
some
think you have
claim
the,
that's already been tried, understanding that you can dismiss it prior to trial?
well, we believe, and if you do, and I'm not accusing you of not doing it, but when one does the research, you can't find something that says that we cannot do it and that you cannot grant it.
Well, do you
And they-
do you have anything that says you can do it?
Yes, the Supreme Court decision.
So
right
that
there.
one thing from the Supreme Court in one of the cases, and the 2 of the other cases, they didn't do it? It seems hard to follow that as a precedent.
Well, I guess we'll find out, because regardless of your decision here, every single Durrani case that's come through this court goes to the Supreme Court for jurisdiction, and they haven't granted any other than the Elliott case, which we know what happened there. The legislature passed a law that said we are specifically overruling the Supreme Court case decision in Elliott. So we're going to get rulings on the motion, because we have filed, when the case goes to the Supreme Court, we file the same motion, and we'll see what they do. If they dismiss the majority of them, then, as it comes back before the court, you'll make whatever decision you make, and then we'll end up with this. I agree, it doesn't give you as a court any guidance, but it's pretty clear that they believe they had the jurisdiction to dismiss it, and they did dismiss it. And they did it without any level of instruction to any of us, but this is where we're at. So we're going to get our answer one way or another. And given the fact the court did this, they believed they had the inherent jurisdiction to do it, at least in this case. And they didn't differentiate this case from any other case. And they
Counsel-
didn't overrule it in the other cases. They just didn't say anything.
Before your time is up, I'm going to address this assertion about whether or not you were served. It's been argued that you said you were not served, and in fact, you were served.
Well, we don't believe we were. We found it in the court's docket and then responded. So there's nothing for me to address other than we caught it and we responded.
But your position is you were in fact not served.
That's our position,
And
correct?
these receipts that counsel's indicated that he has are
They don't
not, in
get
fact,
they don't-
evidence, not evidence of you being served.
I can't imagine what receipt they have from me, because I have a habit across the board, when people ask for that voluntary return receipt, that something came to me, I hit X. I don't respond to requests for receipts one way or another. So I know they don't have a receipt from me, because I don't respond to it from secretaries that send it to me, from outside vendors, from spam. I don't hit
But
yes.
if you weren't required to hit yes, and there was.
There's no requirement.
Excuse me, there was a setting that allowed you to generate a receipt, a read receipt, without you doing anything. Are you aware of whether or not that in fact can
No,
occur?
there is no such setting in my Microsoft email. There is such a setting in my text messages. I can singularly say that I will give you a read receipt to any text message I receive. I can say no read receipts to you, or no read receipts to anyone. And so the only people that get a read receipt on my text messages is my wife, because I don't want to develop a expectation that if I read it at 9 o'clock, you're going to get a response from me at 9:02. So no, I have no receipts that are automatically generated in my electronic mail or in my text messaging. So I don't know what receipt they got and got from who, but we caught it, we're here, and it makes ultimately no difference. But there's the answer, is there is no receipt, period. I don't generate.
I want to go back to the authority of your request. Let's say that this case was never appealed, or these cases were not appealed, okay? And the time for appeal passes, and you decide that you want to dismiss one of the claims, right? So you want to amend the outcome of the case. What would be the vehicle that you would use in that scenario?
Well, first of all, it's beyond explanation that Dr. Durrani fights this, because it's favorable to him. So I would think that getting out of a punitive damage award and an attorney fee award would be something that they would be very agreeable to. So the fact that they stand here and fight it and try to tell you.
Can you answer my question, please?
Well, I'm saying, first, I would look for agreement. And then secondly, I would make a motion to the court, and the court will do what it wants to do.
And what would that motion be rooted in?
The
What civil
inherent-
rule, what would that be rooted in?
Well, the inherent authority of the court to look at and make a decision whether I can remove the fraud claim from the judgment. And I think, since it's my judgment.
It would have to be rooted in somewhere, so, would
Well,
would
I
it be,
think-
for example, would it be a 60B motion?
Well, I don't know that, I guess I could pigeonhole it, and we talked about this last week, into subsection 5. I said 6 by accident, but it's 5.
Okay.
Any other reason the court deems appropriate. So I could use 60B, or the inherent authority of the court.
So looking at it as a 60B if it wasn't appealed, because I can't think of any other place that it would be rooted but a 60B. What is there akin to a 60B under our appellate authority.
Oh, I don't think there's a specific rule enumerating this, but there isn't any case law that says that you cannot do it, and there is no specific rule related to this with the Supreme Court, and they did it
Yeah, that would be my
without
next
comment.
question.
So my authority is Clark, and
Yeah,
you all will
I mean,
decide
yeah.
whether that's authority or not enough, and if you decide it isn't, then
yeah, I
it's-
don't know what the right answer is, but we certainly do limited remands, you know, so if there was something that needed to be changed at the trial court level, it allows us to do a limited remand for the
Well,
purposes of that.
the
But
one-
that's clearly not what took place with the Supreme Court. But thank you. You've answered my time. If you want a few minutes to wrap up, I'll give you, not a few minutes, a few seconds
I just
to
want a
wrap
few
up.
seconds. There's also an issue that they didn't address that I think is important to them and to the court, because the law change is, I'm not standing with any objection to a limited remand for offset. That's one of the things they brought up. The settlements that my clients got from other sources, that was in their brief,
Okay.
that they should get the
So
benefit.
everybody's kind of in agreement on the offset issue.
yeah,
We should
but
go back on the limited remand for the.
Right, but I
offset.
wanted to put it on this record that I don't
Mm-hmm.
object to a limited remand for the set-off.
Yeah, I mean, I don't know what the right answer is, but it seems to me that it could be a limited remand done under a 60B5, because the trial court retains jurisdiction to enforce their order, which is a separate section, and also retains jurisdiction under limited circumstances under 60B. But thank you for your arguments this morning.
All right, thank you.
Thank you.
From Victoria Makarov, who is a paralegal at Taft, Friday, January 9, 2026, 1:05 p.m. to A.J. Statman and Ben Moran, copying Mr. Williamson and others. Sherry Moore Cassette Puckett versus Durrani is the ray line. The attachment is the 2026-01-09 supplemental brief of Appellee's confession of error in this case. Counsel, attach please find that supplemental error. We get read receipts, shockingly, because unfortunately, Appellee's counsel has accused us of this before. We literally had to go to the Supreme Court with affidavits to demonstrate that we serve things properly. Here is our read receipt. At 1:10 p.m. on Friday, January 9th, to Alan J. Statman, subject what I described, date Friday, January 9th at 1:05, was read. We'll file it. You'll see it.
What about this argument that the recipient has to click something to generate that kind of receipt, and they don't do that?
Your Honor, you don't have to believe everything you hear is my argument to that. We have the receipt. We have to, because when appellee doesn't realize that something has been filed for whatever reason or isn't reading their email carefully or enough, they sometimes make this argument. It has happened to us before. And frankly, we'll file it just as we had to with the Ohio Supreme Court, and candidly, we'll ask for our fees for doing it, because we don't think we should have to be put through this. We all serve each other with hundreds of things, as you know, with email. It is only conveniently pointed out when it might serve their purposes that we might not have, which is why we get the read receipts in the first place. I guess we're going to start mailing them, hand delivering, I don't know. But if you let them play this game after you see our evidence, I think that would be a big problem. Counsel argues that we should be in favor of this. Let's be clear. They have waived the fraud claims here. There has to be a remand as to that to at least eliminate the punitive damages and the attorney's fees, just as they have conceded. Our question is, what's the real right answer here? Not just their you could stop with their waiver. You can deny the dismissal motion, but they have affirmatively said in their we do not challenge argument and here today that they waive that. So you have to remand for those purposes. Your Honor, I don't think you can direct the court to enter a 60B5 or some kind of 60B to undo an entire trial. Judge Nestor, Mr. Statman said he dismisses the fraud claim before it reaches the jury, not before trial. You guys are saying slightly different things. What they have started doing, and this has not yet come to the court, but it will, is they go through an entire case with all of the fraud evidence, not a medical negligence claim case, a fraud case, And then right before it goes to the jury, they dismiss, and the judge below is allowing them to do that, even though 41A, as you well know, only allows dismissal by one party before trial. And that's really important, because you don't get to sandbag by putting in all kinds of terrible evidence of somebody else and then
So what,
manipulate it at the
what,
end.
from your perspective, what is that terrible evidence of fraud that is different than the negligent failure to advise regarding or to deceive into an unnecessary surgery? That seems to be it seems to be part of the standard of care, that their argument is you are advising them to undergo an unnecessary surgery, which sounds better than fraud.
Our view has always been that these should be individual trials about the medicine, not the man. And yes, you have expert testimony in which people decide, in which they hear experts about whether it was necessary or not, and often there are competing experts. But what you don't have is all of the other evidence that has come in about, I mean, first and foremost, you have 3 trials at once where juries hear 3 different times about a similar statement made to similar people. In a single med mal case, you would not have evidence of other medical malpractice. That's pretty standard law in Ohio. So items like that, I think, would definitely be different. And we might not win. We lose on single cases sometimes. We've won a bunch, too, when they're single cases, when it's just about the negligence. Our point is, let's find out. Let's follow the rules. Let's do these things fairly. They have said they don't want the fraud claim, so they have waived it here. You have to, at minimum, figure out how to excise that. And what I don't envy this court is trying to understand in Clark what this court is supposed to do when it gets a remand on Clark related to the motion.
Yeah, and I don't want you to misunderstand, or anybody to quote me and misunderstand and pull up the tape and whatever. I'm trying to think this through. So let's say that 60B is the vehicle, just for argument's sakes. I'm not in any way opining as to what the outcome is in the invocation of the 60B to then address the request. So what does it mean to address the request under 60B? I don't know what that means. Does that mean that the whole cause of action is dismissed? Does that mean that a claim could be excised out of it? If the whole cause of action is dismissed, what does that mean from a statute perspective? There are so many issues that are intertwined into this whole thing. What I'm trying to figure out is, what is the vehicle, the proper vehicle to address the request? Because that's step one before we get into, now what do we do with it? What's the ramifications? What does it all mean? So I just want to make sure that, we don't get a request for the tape and Judge Zaya said, because I'm not saying anything, I'm just trying to figure this out.
Understood, Your Honor. I think we all are. It's
Yeah.
definitely a new area. We've given you 2 ideas for that, either enter judgment for us or remand for separate new trials without the evidence of fraud. If the court is
Yeah,
inclined to
but
look at
the
something
issue
else,
is, like, what are we going to root it in? What's the authority that we're
It-
going to root it in? And,
It's a minimum
the
of-
idea of saying, well, the Supreme Court did it, Clark. I don't know what authority they did it in. And then, because then we get into the net effect of it as well.
agree. We think at
Yeah.
minimum it's a waiver. All I would ask is that if the court sees a new path and it wants more briefing on it, we would be happy to do that. Thank you, Your Honors, for your time.
All right, thank you. Thank you both for your arguments this morning. I know we have a lot of issues, and this is an ongoing case for both of you, and, clearly a lot of important issues that are before us each time. So we'll take the matter into submission and issue a timely decision. I hope you have a wonderful afternoon. Good morning. All right. Whenever you're ready, you can come to the podium.
May it please the court, Jeff Randall, on behalf of the appellant, and Alcohol Authority Council.
Attorney Bando, would you like to reserve time?
3 minutes, please, Your Honor.
All right, yeah.
And I apologize. I suffer from a little bit of a hearing loss.
Okay, I'll talk louder.
Could just speak into
Okay.
the microphone a little bit closer.
No
It helps me
worries.
a lot.
No worries. And if at some point you don't hear me, don't feel inhibited to let me know, okay?
It's my own fault, Your Honor. Too much
No, it's
blood
not your,
said
it's
one
not
of
your
my
own.
absolute leading plans back in the 70s, so
That's okay.
Thank you. The issue on appeal is a novel one here in the First District. The question here is whether the failure to install a safety modification, a grab bar, constitutes a physical defect in the object or instrumentality itself, the shower. We respectfully submit that it does not. That the failure to install a safety, a grab bar in a shower does not constitute a physical defect as that term is used in 2744-02B4.
So it's my understanding the term is not defined in the law?
It's not specifically defined by the General Assembly, Judge Nestor, but there are cases that have defined the words physical. And
It
there are
seems like
cases-
the cases are all over the place.
There are cases that are all over the place, but I think the great weight of those cases stand for the proposition that the failure to install a safety modification does not constitute a physical defect. And we've cited those cases.
So why shouldn't this be a question of fact for the jury as opposed to a question of law for a court?
The question, because I think the question of law, the broader question of law, is whether or not the failure to install a safety modification constitutes a physical defect. That's a broader question of law. If this court would decide that the failure to install a safety modification could constitute a physical defect, then I think it comes back to the trial court to decide whether or not that is, in fact, a physical defect. Then it becomes a question for a jury. The cases that have addressed this issue, the cases that we've cited, the Solar case, the Duncan case, the Parmenter case, the Smiley case, the Bryan case, all address this as an issue of law. None of them said, oh, we're going to remand this back and allow the trier of fact to decide the issue. It's a question of statutory interpretation in many ways. And
Well, I think physical, which sometimes is challenged in some of these cases, it seems to me that that's not an issue here, that portion of physical defect.
right, it's having a material existence perceptible through the senses and subject to the laws of nature.
Correct. And some of, that seems to be at issue in some of these cases.
And-
So I think the issue before us is defect.
And whether or not a defect, and it's an imperfection or abnormality that impairs quality, function, or utility, and there's no dispute in this case that this shower served its purpose. It served its utility. She used it for 2 years without any issues. And just because this shower doesn't have a grab bar doesn't mean that it's a physical defect. My shower doesn't have a grab bar. I would
Right,
submit
but
that
she
most
asked,
showers don't.
for the grab bar to be installed because of her own physical deterioration, correct?
She did.
So she can, and the shower should be able to be used safely, is that right?
Correct. She did ask for it in June, and the Housing Authority, she asked for the shower, she asked for a front rail, a guardrail, and she asked for a motorized garage door. The latter two items were installed promptly. The Housing Authority vendor did not get to the grab bar in time.
So the
and I
more
submit
difficult
that that
items
goes-
were installed.
I'm sorry?
The more difficult items were installed.
Yeah, there
And-
were 2 of the 3 were, but
But counsel,
that goes
but-
to the negligence question, Your Honor.
No, my question is that for the shower to function as intended, it had to be able to be used safely. Would you
Yes.
agree with that?
Yeah, if it has to be able to use safely, and that shower, that tub was used safely for 2 years without incident, and I would submit that most showers do not have grab bars, and we would not consider them a physical defect. It wouldn't
So
constitute.
are you asking us to
infection or
consider lack of
abnormality.
injury as to, for a period, as to whether there's a defect? Because oftentimes there's a defect and there isn't an injury, but then eventually there is.
And if obviously there has to be an injury for her to have a cause of action.
Right.
But in this particular case, if the absence of a grab bar, follow their theory, if the absence of grab bar constitutes a physical defect, then there's nothing to stop the absence of any other safety feature from also being a defect. So is it a
But I
defect?
think their argument is a little bit, it seems to me that their argument is that the absence of a grab bar in this particular circumstance is a physical defect. And let me just, I find the case Moss versus Lorraine City very interesting. So that one has to do with a special needs classroom and a kitchen in that special needs classroom.
Right.
So while that kitchen may have been appropriate in any other classroom, because this was a special needs classroom, it was deemed to be a physical defect. So how is this different to that case? Because in this case, we have that it's been approved, we have a basis for the approval, and given her physical conditions, the need for grab bar, which has been already approved. So how is that different to that other case?
I think that, number one, I think the Moss case is somewhat unique, given the factual circumstances of the case. And in that particular case, the theory was based on a negligent design and construction of that particular kitchen within that classroom that addressed special needs students and the 7-year-old boy that was injured.
So that was a build-out, and this is an add-on?
This is a grab bar that she asked to be installed, but she's never made a claim that the shower itself was negligently designed or that it was negligently constructed. That to me is the key difference between Moss and what we're confronted with here. Moss is the outlier. All of the other cases that we've cited support the proposition that the failure to install a safety feature that might make it safer does not make it a physical defect. And I think the Duncan case in particular is probably the best of the 4 or 5 we've cited that supports that proposition, because that was a safety defense class, and the theory was, hey, you didn't provide mats on the floor that would have prevented this particular injury. In other words, you didn't provide this safety feature. And the court in that case said, wait a minute, no, that is not a physical defect as the General Assembly uses that term
But it seems to
within the
me
statute.
that then goes to whether it was a necessary safety feature, which then seems to me that's something that goes to the jury.
It could go to a jury and if I did not express my answer more clearly in response to Judge Nestor's question, but only if the broader question is answered first. And that is, it's a question of law as to whether or not the failure to adopt and include a safety modification constitutes a physical defect. That to me is a question of law. And the cases that are cited both in our brief and by my esteemed colleague also dealt with it in that way. So I don't think the issue that we've presented to this court is one that you can just easily remand and say, well, that's an issue of fact for the court to decide, for the trial court to decide. It's a broader question.
In the Duncan case, had anybody asked for extra padding? Like any
Duncan-
participant in the courses say, hey, I'm not going to do this until I get a pad.
I don't recall that specific fact, Judge Nestor. I recall that the theory and the claim is that you didn't provide me with the mats for the floor during the safety defense class, and had I had the mat, then perhaps this injury would not have occurred. That's what the takeaway from that case was.
I mean, it seems like in this case, it's a little bit different. She asked for it, and for some period of time, it was not delivered.
Agreed. There's no dispute, and we've never run from that fact. But that goes to the question of whether or not the housing authority was negligent. It doesn't address the question as to whether or not the failure to have the grab bar constitutes a physical defect.
Well, counsel, I think you conceded that for the shower to function as intended, she had to be able to use it safely. Is
For
that,
the
did
shower
I
to be
understand
able
that
to use
correctly?
For her to be able to, as long as she could use the shower to achieve its intended purpose, to clean herself,
Safely,
to take a shower
safely.
safely, and just like you would operate a car,
And
safely.
this 70-year-old woman with a bad back who lived by herself submitted documentation that she could not use this shower safely without the grab bar installed.
She did submit documentation, but to me, that does not make the fact that there's no grab bar, does not make it a physical defect. It does not constitute an abnormality. It does not constitute a physical defect as we understand those commonly used terms. The Moss case that Judge Zayas asked me about seems to be the outlier case. It's one of the ones that Ms. Dove has relied upon. The other one was Leisure versus Adena Local Schools, and that again is distinguishable because that was a case where bleachers were put up and they weren't put up the right way. They didn't install them the right way. And so you could make a clear-cut distinction that that was a physical defect because the failure to put those bleachers together correctly to extend it out is what then caused the plaintiff in that case to be injured.
And the
The only
failure to
other
put the
case-
grab bar in the shower is what caused Ms. Dove to be injured in this case.
We don't know that. Ms. Badub said she was taking a shower, she slipped, and then she fell. We don't know that the grab bar in and of itself would have, had it been there, would have prevented her injury. We don't know that, but I don't think it's a necessary question for this court to answer in addressing this legal issue.
Yeah,
The only-
I think I see it a little bit, like just a smidgen differently, like the bleachers. The bleachers, they were supposed to be installed a certain way, and they were not installed that particular way, okay?
All right.
The grab bar was requested and approved because of her circumstances, and it wasn't installed, you know?
Correct.
The
That's-
safety tape is a little different because the safety tape was something that could have made it safer, but it wasn't something that had already been deemed as needed to take place under these circumstances.
Right, and I-
Okay? So I think that that's kind of like the difference here. Like the bleachers, there's already a predetermination that it should be a certain way under the circumstances, meaning this is the way it's to be installed, but it wasn't installed in the way it's to be installed, right? So in this case, there's this request and approval, and the request is not just, I like the idea of a safety bar because I like to hold on to it while I shave my legs. You know, the reason for the safety bar was because there was a physical condition that then would have protected, that safety bar was giving her a level of protection.
She did submit a medical documentation to say that she needed that because that's required in order for the housing authority
Right,
to
right.
install
So
it.
it's already been, it's as if this, if the safety tape was something that it was already deemed because of the illumination of the room, that we're supposed to have safety tape, and, and then there's not safety tape, then that case would, I think there's a good chance that case would have come out differently.
I'm not sure that I agree with that. I think,
Okay.
when I think of the safety tape, Your Honor, I think of the Bryan case, which is
Okay.
the one where the school bus garage and the pit within the garage, and where the plaintiff was making the argument that, hey, it was a physical defect because you didn't have the safety tape up, or you didn't have this painted so that someone could avoid this pit, right? But again, the court in that case said that's not a physical defect. And so I think that case, again, Duncan, the Parmesan case, the Smiley case, all support this proposition that we've advocated, that the failure to adopt the safety modification does not constitute a physical defect. And to close out here, if you take plaintiff's theory, if you take that theory of liability to its endpoint, okay? Under their logic, a building is defective whenever it could be safer, even if the instrumentality itself, such as the shower, functions exactly as designed. And what that does, if you adopt that theory, you collapse this into a general duty. You collapse it into negating what the General Assembly meant when they said physical defects. And it bears emphasis that the presumption is that we're immune as a political subdivision of the state. It's their burden to establish one of those exceptions, because the presumption is we are entitled to immunity, and the General Assembly has made that declaration. We may not like it, we may disagree with it,
Thank
but
you for
that's
your
what they've
argument.
said.
Thank you.
Thank you.
Good morning.
Good morning, Your Honor. Your Honor, we're here today because of some facts. It is very fact-specific, and I think that the timeline is important here. CMHA approved the grab bar to be installed, amongst two other things that were installed in this case. They approved it. The doctor, Ms. Dove, submitted the approval from her doctor. So before she even gets to the approval of the CMHA court, or CMHA board, she has already had to submit some evidence from her physician that she is medically required to need this. And they approved the condition. This wasn't, she asked for it and she deserves to get it. They approved that they should install it, and they knew they have to
It
install it.
seems like that goes to the idea, though, of negligence and not the idea expressed by the appellants regarding the definition of physical defect.
I agree with you. I guess the point I'm trying to make with that is that in all the cases that are cited, none of these safety features or accommodations are going through an approval process. The paint, the tape, the bleachers, nobody is jumping through the hoops that my client had to jump through in order to get this approved for this accommodation.
So
And
what you're
at the
saying is
point-
that approval and the basis of that approval is the nexus of what makes it a defect?
And once it's approved that it is necessary for her safety and well-being, not just by her physician, but by the CMHA themselves, then, yes, then it's a safety feature that as of the approval by their own people, then it becomes a physical defect. That shower no longer operates as it is intended to be used because, based on their approval, not somebody else's.
See, and that's why I find the Moss case interesting, because that approval, the way I'm seeing the argument is that approval makes it a defect for her as the user of the shower. So while the shower might be fine for me to use, right?
Yes.
But it's not for her to use, given the basis and the approval of the bar, which is why I find the Moss case interesting, because while it does go to the construction of that kitchen, right? But it's that kitchen in that scenario with a special needs class. So if that kitchen had been in another classroom, it might have been fine, but not in this classroom.
Correct, and that's why there was this medical accommodation and this approval process, which is not easy. Also, the approval process, she was approved for three things to medically accommodate her for her medical condition. They installed two of the most significant ones, and the cheapest and easiest fix for her, which I would say is more necessary medically for her to be as part of in the shower. I mean, so many things happen in the shower versus, in the garage door. It's something you use every day, and it would, and it's for her specific, the process for the approval is so specific to that person. CMHA certainly, testified that these accommodations, these medically necessary accommodations, happen in maybe 5 to 6 people per year. They get thousands of requests for, maintenance requests that they say they will fix in 30 days. They
Counsel,
generally.
what did the approval from CMHA look like? Did it say this is necessary for the safety of this resident?
Yes, so it's a medical necessity approval that outlines what they're going to do and what they have agreed to do to make the accommodations for her.
Right, but did they specifically concede that this was necessary for her safety?
Yes.
Thank you.
And then,
So it seems like this would make immunity kind of almost always subjective. It would depend on the particular plaintiff as opposed to the blanket immunity that I think the appellants would assert applies to a political subdivision.
well, in the physical defect part, in this particular case, yes, is specific because it is predicated on the defect being something that wouldn't be an ordinary defect, but because of the class and the approval that they gave, would apply to her and these conditions. And if it only applies, my defense counsel said that they're worried about the overlying rule that may come down out of it. And if only 5 of these medical accommodations are approved, it's not something that's happening every day. It wouldn't apply blanketly. It can be specifically narrow enough that if these are, if they say they're going to do it and they agree to do it, that they have to do it. And that if they don't do it, then the immunity shouldn't apply to them if it is a physical defect. And in this case, the physical defect was that the shower was no longer functioning as it should function for this particular plaintiff in this case, given their prior approval. I think the timeline speaks to itself. Their testimony says that for regular maintenance that isn't required and that they shouldn't get immunity for, they complete within 30 days. This was over 5 months, and she didn't get a medical accommodation that they approved. So I think their approval gives them their approval then creates the physical defect. That didn't happen before that she had that in place. And she went through and jumped through the hoops to get that approval. So I don't think this is something that is blanketly going to affect all of the, it doesn't give them, it doesn't grant anybody who's asked for, a light bulb to be changed, immunity in a situation, it doesn't instill liability on them for every single maintenance, only for these specific circumstances where, the utility and function of the item that was requested, the utility and function of the item, the item is no longer what is intended to do and serve the person. I think.
So for example, in Moss, the court basically concluded that there was an issue of fact regarding whether or not the kitchen was defective. Would that be an issue in this case? Like, if it went back, would the jury determine whether or not the lack of the safety bar was an actual physical defect, or is that even something that the jury could consider? Is that something that would be in the nature of a jury interrogatory?
It would be up to the plaintiff to prove that it was a physical defect. But, yes, that's our burden to prove at trial. And that is the issue of fact to be decided, which was why, summary judgment wasn't granted on the issue of immunity or negligence. I think that the absence of the safety equipment definitely constitutes the physical defect of this, and this case in particular offers even stronger evidence of that than Greenville or Moore. I think that, and that's what the trial court relied on when they made their decision, that the lack of the safety equipment or other safety features could amount to a physical defect, defined by the perceivable imperfection that just diminishes the worth and utility. And after the approval was approved by CMHA, that no longer functioned the way it should function, and their failure to do so, to fix and maintain the safety equipment that they approved led to, obviously, the plaintiffs. In this case, in Moore, it was remanded for determination whether the absence of the required smoke detector was the actual physical defect. So we asked that this would be remanded in this case so that the jury can make the determination for it. This case is different because CMHA approved the condition. It was medically necessary and documented, 5 months, and it was not installed when other minor and things were satisfied in 30 days for thousands of requests. Yet something that happens only 5 times a year, 5 to 6 times a year, couldn't be done within 5 months. I think the law is clear about the absence of the safety equipment can be a physical defect, and that's what we're asking this court to decide today. And that, in leisure, the defects arise from the maintenance failures themselves. And further, and counsel and I are both here. We're here a few years ago on a similar case involving CMHA before in Johnson, where they found that the mat was a physical defect and was remanded back to the trial court. So in this case, we ask that you affirm the denial of summary judgment and remand back to the trial court.
So you were on Johnson?
Yes. Counsel and I were both on the.
And did that actually go back for a trial?
It did, Your Honor.
And was there a trial?
It was resolved outside
Okay.
of.
Because I'm just wondering, how, it seems to me the question here is who is suited to make the determination of the definition of physical defect? It seems like maybe it could go back. I wonder if any of these remanded cases actually went back and there was like a jury interrogatory to say what is a physical defect. Has that ever actually been tried as an issue, or is it just, determined and then the parties resolve it because a court says that you're either immune or not immune? You get what I'm saying?
Yes, I do. Unfortunately, I don't have the information of what happened to the cases after they went back to the trial court in these circumstances that counsel and I both cited today.
Because it seems to me if you're trying this, theoretically, the appellants could ask the jury, or they could even ask for an instruction about how to define physical defect, and they'd be stuck with either the definition that we've given in Johnson or other definitions that might be asserted at the time of instruction. I imagine there's no instruction on the term physical defect.
I mean, unless it's a specific, jury interrogatory to the nature of the case, or, but it's certainly one of the elements that would need to be defined, we can hash that out. I'm unsure about how in practicality it would happen at remand.
Thank you.
I don't have anything further.
All right, thank you.
Thanks.
Just 3 points I think I want to make.
Well, let me ask you, I mean, it seems like in a lot of these appellate cases, the courts have said whether or not there's a physical defect is a genuine issue of material fact, and then it goes back to the trial court.
It can be, as I said earlier, but that's only after, in this case, the broader because this case involves the installation of a safety feature. And that's a broader question that I think that is a question of law that I think this court can decide. If you decide that the failure to install a safety modification can constitute a physical defect, then I think it gets remanded, and that becomes a question of fact for a jury to decide on remand.
And then what would you do? You'd go back to the jury and say, okay, here's a definition of physical defect, and you'd have dueling definitions of physical defect, and then you'd get an instruction from the court and an interrogatory?
I think there would be an instruction from the court on the definitions, and I think there would be a special interrogatory for the jury to answer, and they would address it that way. Ms. Achani mentioned the Takitha Johnson CMHA case, which she and I had handled and argued back in 21 or so, somewhere around there. That case is markedly different. It involved a woman who had slipped and fell on a worn step pad on a step inside of her unit. That had nothing to do with the installation of a safety feature. So factually, it's distinguishable and didn't present the issue that we've asked this court to address. Secondly, counsel is emphasizing the facts in terms of the approval of this safety bar by the housing authority and the failure to install it. I understand that. I've never disputed that. I've never run from it. But what she's doing, with all due respect, is conflating the evidence of negligence, and that evidence would go towards the negligence question, with whether or not the shower itself has a physical defect, and that's a separate question. The implications of what they're trying to say here is, you didn't install this safety feature, therefore that's a physical defect. So does that mean that if the housing authority, or the housing authority or any other political subdivision fails to provide a bath mat, does that mean that tub is no longer safe and it's a physical defect? Does that mean that if I don't put traction strips on my tub automatically in every tub for every public housing unit we have, that's a physical defect?
But that's
because
not-
that's where they're going with this theory.
And I guess I want to push back on that a little bit, because it sounded like they were specific to this particular case, where CMHA approved the request, and the approval specifically said that this shower cannot be used safely by this tenant unless the safety bars is installed, and they did not install it.
I don't think the record goes quite that far. I think the record shows that she asked for it, it was approved, and that it was approved based on medical documentation, but it was never said that she couldn't use the shower without it. In fact, she used the shower repeatedly without it.
Well, I guess that's my question. What did that approval look like? Was it just a box that was checked that said
Box checked
approved?
by the doctor, to the best of my recollection, Your Honor.
But in terms of CMHA's approval, did
Yeah,
it say
they
this
just-
is necessary
They get the
for safety?
documentation from the doctor. It's a, ministerial function at that point to approve it, just like they did for her garage door and for her railing.
And I assume the doctor's note specified that she needed this to be able to shower safely.
It didn't, I don't think it went that far. It just said, I think, my recollection is that he approved it, that she needed it.
Okay.
But
And CMHA said, we agree.
they approved it. But what, this all goes back to, plaintiff's theory then is making it user-specific. And it's not user-specific. You don't, when you look at the intent of what's worded in the statute, it doesn't say that.
Well, I think it's not really, it's basically, it's,
It's
the
not
focus,
determined by the
yeah,
user, is
yeah,
what
the
I'm-
focus
is what I'm
seems
trying
to be
argue.
on the approval and the acknowledgement of a medical condition. and I'm going to use the word necessitated, but I'm using that word absent, seeing what the language of the approval is, okay? But their argument seems to be premised on that it was necessitated in order for her to use that shower.
Correct.
Okay?
And in closing, what I wanted to emphasize.
And that was already
It
predetermined.
was predetermined that she had asked for it, she submitted the documentation, it was predetermined that she should get it, and I don't dispute that it wasn't there on November 20th when she fell. The cases, as I emphasized before, the majority of the cases, I think, support the proposition that we've been advancing, that the failure to install a safety modification is not a physical defect. I acknowledge the Moss case and the rationale that's in there, but that's.
I mean, it's not on all fours, it's just like an interesting
I understand,
sort of,
and that's what's made the practice of law interesting.
Absolutely,
but-
yes. That's why we're here.
Yeah, and which brings me back to, and I'm always reluctant to quote a dissent when I'm the appellant, but without any clear guidance from the Supreme Court on this issue, we've got this Doe case, which was cited by the trial court, and it was cited by my esteemed colleague, Ms. Alchani. But that was a plurality decision. But when you're looking for solid rationale that makes common sense interpreting the statute, Justice Kennedy's dissent in that particular case lays out some pretty solid rationale that supports the position we're advocating and in a common sense interpretation of what physical defect is meant by the General Assembly. And again.
And tell me again what case you're referring
It's
to?
Doe versus Greenville School District.
Okay.
It's in a Supreme Court case. It was a plurality decision written by Justice Stewart, I believe. So it's not binding precedent because there was no
Because it was
majority
a
support of the
yeah, I
rationale.
get it.
In that case, doesn't Kennedy say one of the definitions of physical defect is want or absence of something necessary for completeness, perfection, or adequacy in form or function? As to this plaintiff,
Yes.
the whole situation was not adequate in form or function.
Right. But in that particular case, you had a situation where you had the high school science lab, and they had with flammable liquids and chemicals and combustible items, and they didn't have a fire extinguisher. And Justice Kennedy said that doesn't make the classroom, the fact that it didn't have a fire extinguisher, that didn't make the classroom a physically defective, right? And so, and she said whether it should have had one is a matter of policy or judgment. But
And I
that
think
rationale-
I think that's where it comes back to the argument of like, there's a predetermination that it should have had. But thank you for your argument this
Thank you,
morning.
appreciate it, thank you.
Thank you both for your argument this morning. We're going to take the matter under submission, issue a timely decision, and I wish you a great and somewhat warm remainder of the week.
Thank you.
Good morning. Good morning. You can take a seat. Attorney Whitfield, when you're ready, you can come up to the podium.
Good morning.
Good morning.
Morning.
I hope you had a good weekend.
It was cold,
It was really cold, it was. Yeah,
but it wasn't too bad.
yeah. We had our sunny moments,
Sunny days. Very cold.
yes. Would you like to reserve time?
Yes, please. 6 minutes.
Okay, all right. Whenever you're ready.
Thank you. May it please the court, good morning. James Whitfield on behalf of appellant Mr. Jones, who's joined with me today. We've been here before. Mr. Jones continues to seek custody of his son. I'll start just by reading, the Supreme Court has read that parents that are suitable have that paramount right to the custody of their minor children unless they forfeit that right. A contract abandonment or becoming totally unable to care for and support those children. And that last phrase has nothing to do with Mr. Jones. He's more than willing, able, and can't wait to fully support his child and to have custody of him. Like I said, we've been here before. The court previously found that he had abandoned a child that he really didn't know was his child. The court sent it back down for a specific purpose, and that was to determine whether or not custody would be detrimental to the child. And this court has looked at that same exact issue before in a similar case back in 2019. I think that was the HJH case. But the trial court in this particular case continues to make these reaches to try to find Mr. Jones unfit. They ignore a lot of the evidence that points to his ability to raise his son, to provide for his son and care for his son, and instead looks to these almost random things to a certain extent to find him unfit. This particular instance, the court focused on the fact that he wanted to get some information about his son needing surgery, eye surgery specifically. And there's a lot of discussion in the decision, and the magistrate, the way she phrased it, she said that Mr. Jones even filed a motion to try to stop the surgery. But that's not what he did, number one. Number two, he should be concerned about his son because when he heard that they were having surgery, no one had informed him because he didn't have custody at that time. So what he filed was a request for an expedited hearing. That hearing never took place. He filed that hearing to gather some information. Her decision
So
goes on.
what you're saying is the determination that he tried to stop the surgery is not supported by the record? Is that what you're saying?
It's not accurate. It's very inaccurate. That's the way she phrased it. That's the way counsel phrased it. But that's not what he did. He couldn't do that. He didn't have custody at the time. If the grandparents wanted to have this procedure done, they could have did that. It was scheduled at one point, and then they canceled it. Mr. Jones couldn't cancel it. Mr. Jones didn't cancel it. He did ask and say, hey, we need to have a hearing so I can find out what's going on. One of the exhibits that was submitted by Appali was a letter drafted a month after his pleading. And that letter did not say this is required, we need to have this down. It recommended the surgery and gave Mr. Jones a little bit more information. And when he was testifying about that in the trial, he said, I've never wanted to stop the surgery. I wanted to get a second, maybe a third opinion. I want to know what's going on because he heard things. He heard that there was some risk involved, and he wanted to know about those risks. That's what a parent does. That's what a parent is supposed to do, let me put it like that, and that's exactly what he did. But the magistrate in her decision, and the judge upheld it, said that he caused the child detriment by doing that, by trying to get information about his child's surgery.
Well, it was characterized as against the eye surgery. Father was against the eye surgery.
He wasn't against it. He wanted to get more information. He wanted to push it out. He wanted to delay it. He wanted to have custody, actually, when he took his son to get the surgery, if his son, in fact, needed the surgery. He wanted to try to get other opinions. He couldn't get the other opinions because, again, he didn't have custody. When he found out his son needed eye surgery, he knew there was an issue with his son's eye because he'd been wearing eye patches. And the record reflects that Mr. Jones went out and got eye patches for his son. So he knew that there was something going on with his eye. When he found out surgery was needed, he filed a motion, an expedited request, or an expedited hearing request, so he could find out information about that surgery. And again, that never took place. But that's one of the reasons they reached out to try to say custody to dad would be a detriment. And that's almost, in my opinion, it's close to ridiculous. I think the other thing that was noted, the magistrate said she had concerns about mother's testimony in this case. Mother has given up, I won't say given up her rights, but she was in agreement with her parents having custody. Her mother's been in and out of not only this child's life, but all her other children's lives throughout, due to her history of drug use, drug abuse, things like that. She came and testified, and this is all new. These are new things. The first time when they said Mr. Jones abandoned his children, none of this stuff came out. But the second time, now he's in trouble for asking about surgery, and then mom came in and said, oh, dad gave me drugs when I was in his house. Dad did this, dad did that. Well, did dad use drugs? No, he didn't use drugs. Did dad drink? No, dad didn't drink. Mr. Jones took the stand and said, I never gave her drugs. He acknowledged that she came to the house. They had a relationship. Obviously, they have a child.
Counsel, if I could turn back to the request for additional medical opinion. Is there any limit on the number of requests that a parent can seek before allowing the medical care to occur? In other words, does it become interference at some point if there's ongoing requests for additional?
It could. I think it could. I mean, obviously, it'd be case-by-case basis. In this situation, my client he tried to seek one doctor's opinion, but couldn't get that. But obviously, there's no legal limit to how many opinions a parent or anyone, a provider, custodian can seek before rubber stamping or saying okay to surgery.
Right, but demanding additional opinions can at some point become interference.
It could, yes. We definitely would say that, but that's not what happened in this case. Again, my client asked for a hearing to get information that he never received. There's no way he could stop the surgery from happening. The surgery, in fact, happened the day after the trial took place. He never said, okay, I'm fine with it then. He testified about the fact that he would do what he needed to do. He testified about the fact that he would make sure his son's medical needs were always met, whether it is his eye or anything else. But he didn't delay it. He didn't cause any delay. The finding that he somehow was a detriment to his son by asking about an initial opinion, again, I think that's ridiculous. The testimony about him supplying drugs and things of that nature, again, was false. But even if it were true, this court has found and held that you look at the parent's current situation, his current suitability, not the things he's done in the past. So if he's got a criminal record for 20 years ago, that the magistrate again highlights, notes, and talks about domestic violence and things like that, none of which had to do with mother in this case or anybody in this case, which predated the birth of the child by 10 to 15 years. None of that seems to matter. If he was supplying drugs to her in the home, obviously that's not a good thing. But again, that was pre the child's birth. There was no evidence whatsoever that he supplies drugs, buys drugs, sells drugs, gives drugs to anyone. There was discussion about his current girlfriend that he brought up, or a current lady he sees. I don't know if it's his girlfriend or not. But she's had some issues with substance abuse. But she's not parent, she's not trying to get custody. And I see my time is up, so I'll reserve it.
Okay,
Allow
thank you.
Mr. Berry to speak.
Morning, Your Honors.
Good morning.
Brad Berry on behalf of appellees. May it please the court. I believe we're in front of the court for two issues. One that's been discussed quite a bit at the prior hearing. The first issue was, did the trial court conduct an independent review of the evidence offered at the August 22nd trial, August 22nd, 2023. This court remanded it on February 21st, 2025. The court did issue a decision, I believe, it complete some pretty exhaustive analysis on its own and came to the same conclusion after an independent review of the facts and evidence. The court did find competent and credible evidence to support the issue in this case, which the second issue is, did the trial court properly determine that it was detrimental to place this child with mother and father?
Yeah, it seemed like the trial court relied on three things. One was that the trial court determined that the father was against the eye surgery, that the father had provided crack and fentanyl to mother, and father's criminal contacts. The criminal contacts, as I understand, those were ultimately dismissed, were they not?
I would say the criminal context that Mr. Father presented his own criminal record to the court and made it an issue. And I would just rely on Father's exhibits. I think there were some convictions. I think they were rather old. And there were some domestic violence issues in the past. I would agree with the court that of the three, the criminal record is probably the least impactful in this case.
Okay.
I would think that the medical issue, the surgery was
Okay.
certainly the.
Yeah, I mean, I started, like, I was like, okay, let's start with the low-hanging fruit. All right. The had provided crack and fentanyl to mother. The arguments this morning centered on that those were, if they had occurred, that they had occurred before the birth of the child. Is that reflective of the record?
They did occur prior to the birth of the child. The child was born addicted to drugs. Why is this current?
So now we're left with the father against the eye surgery.
Well, but the other testimony that the court heard was really important testimony and had to do with the credibility of mother versus father. But father made the drug issue current to this court by saying and admitting he has his girlfriend who is drug addicted. She's addicted to fentanyl. She is currently in a drug program. Doesn't mean that she's completely sober, but she's also spending the night at father's residence. She's also around this child, which had an immediacy issue, and I think a safety issue. The court was in a really good position to view father's testimony and mother's testimony, and also the Renfros also witnessed this person, the girlfriend, the drug-addicted person, around the child who was 3 years old at the time. The concerns that were brought up to the court were if there was drug paraphernalia in this residence historically, and there's a person in this residence now that's addicted to fentanyl. That would be the drug issue. The final issue, which we heard counsel state today, was father didn't intend to stop the surgery when he filed the motion. He just wanted some additional time.
Can I go back to the drug use by the, what we'll call girlfriend? Was there evidence that she was currently using while around the child? Because I know you said she was in treatment, but was there evidence that she was an active user while the child was around?
I believe the evidence was from the mother who testified that that the girlfriend had recently been kicked out of the drug program, that when they were there together, she was still using. So that was the concern, I think, of the court. So the evidence of whether she was using at his apartment, I don't know, but just that she currently was unsuccessful in the program. Going back to the initial, the surgery, the medical surgery, the eye surgery, and the immediacy of that, father said it wasn't his intention to stop the surgery. The testimony, and there is significant testimony on that, which is cited in the appellee's brief, but father requested an expedited hearing on February 9th, 2023, for what he says was an exploratory purpose. On June 7th, 4 months later, the Renfros were able to get a third evaluation scheduled at an ophthalmologist for the review of the need of this surgery. They invited father to attend. Father was an hour and a half late for that surgery. When he did show up and heard from Dr. Laura Coyne, she did recommend that this child immediately proceed to surgery. That's at trial transcript, page 46. Father's response is telling. He says, "You'll be wasting your time. I'm going to get it stopped in court. It's a waste of time to schedule surgery, and I'll get it stopped." He was, and if you look the trial transcript, the witnesses that testified, he was militant during this this doctor's appointment. He was argumentative with the professional, with the expert. There was no mistake that he wanted that surgery stopped. When asked about it at court, what attempts did he make from February when he filed his motion to June, or actually to August 2023 when we were in court, he did say, "I tried to find a doctor in Cleveland but was unsuccessful with it." 9 months that he had to find his a different opinion from the three professionals that were recommending the surgery. And he didn't have an answer, right? I think the court was justified in finding that it would be detrimental to allow father to have custody of this child based upon the totality of these circumstances, based upon his parental decision-making ability. There was also testimony that father was riding around with a 3-year-old, allowing him to drive his car in a parking lot during one of the, at an exchange. That was direct testimony from.
Counsel, going back to the medical issue, you would agree, I mean, a parent does have a right to have their questions answered, especially with respect to something like a medical procedure.
I would.
So was there anything inherently wrong with father pursuing additional medical opinions to quell whatever worries that he had?
None whatsoever. None whatsoever. And I think that's why the grandparents did take a pause. They had the surgery scheduled in February when he filed the motion. That surgery was paused. It's in the transcript. And they found another doctor at Children's Hospital to give yet another opinion. Why? Because they wanted father to be able to participate in that consultation. The child was present. So no, I agree that it's absolutely a parent's right. And the grandparents gave him every opportunity to not only participate in that third evaluation, but to also seek his own expert.
So what would the mechanics of that be, seeking his own expert? If he didn't have custody, how would that work? Was everybody okay with him, like, taking the child to Cleveland Clinic, for example, if that was a possibility?
There was no requests by father to do so. I think that there's ample evidence at this trial that the grandparents really were bending over backwards to comply with father's requests. They granted him additional parenting time when he would ask for it. They modified the schedule. They made sure that he saw the child for holidays. I have no reason to believe that they wouldn't have complied or taken the child to the appointments. I won't belabor the detrimental argument only because I spent a lot of time arguing that before this court months ago. But we do believe that the answer is yes to both. An independent review was conducted by the trial court. We believe that they were correct when they determined that it would have been detrimental to award this child to father. And with that, I'll rest unless there's questions.
All right, thank you.
Thank you.
Thank you.
Whenever you're ready.
With regard to Mr. Jones' friend, and I won't name her name, but I'm not sure if she testified. I don't want to go too far astray. He gave me her card. She works at the CAT Center. She's a peer recovery supporter. I think mom testified that at some point, she knew the girl. She knew the young lady. She wasn't pleased with whatever her and Mr. Jones were doing. But this young lady never used any kind of substance in front of the child. Mr. Jones testified, and it's in the record, he got parenting time, received parenting time, I believe it was like March of 2021. He's been consistent in exercising that parenting time. There's never been any issues with his child during that parenting time. The visits occur in a well-furnished home. The child has his own room in that home. We provided exhibits to that, evidence of that. Like I said, there's never been any issues whatsoever. To the judge's point, he doesn't have custody. He only saw his child on the weekends. He would ask for additional time from time to time with the grandparents, but a lot of times that wasn't granted. They never granted it a chance for him to take the child to the doctor.
Well, their version of that is that they were never asked, that they paused, they got another opinion, and if he had asked to take the child somewhere, they would have given permission to go to an alternative provider.
I mean, if we brought him up here to speak, he would tell you that he's asked. And I think what we can look at, and this is in the record, like I said, he filed his motion in February. There's a letter dated March. It was Exhibit 4. It was from, I forget which doctor, but it's from a physician. I can tell the court. I've got it right there. But Mr. Jones never spoke to that doctor. And then there was a subsequent doctor in June. And I don't recall him being an hour and a half late, things of that nature. But he did want to still get another opinion. And to what counsel said, he was adamant about stopping that surgery. I'm not sure what he could do. He didn't do anything. There were no additional motions filed. That's the only thing he could have done. Like I said, he never had a hearing on his first motion that he filed. He didn't stop the child. He didn't kidnap the child. He didn't do anything crazy. He did not try to stop the procedure. He wanted information about that. And it never came from him. But like I said, he's tried to do everything he could do to form a relationship with his child. He's formed that relationship, and all that stuff was ignored. They didn't talk about the bond that he's been able to build with his son. They didn't talk about that he's never had JFS involvement. They didn't talk about, again, we brought up the criminal history because it's so dated. He hasn't done anything for 15 years. He didn't do anything related to the mother of the child. He's gainfully employed. He has a vehicle. He's never had any mental health issues. He doesn't have any physical issues that stop him from taking care of his child. No health restrictions at all. He doesn't consume alcohol. He's been clean and sober for over 20 years. Mom testifies she's never seen him use drugs or drinks. He brought it up. He said he used to drink and use drugs when he was younger. He gave that up. How is he unsuitable? And so the second part of our brief, he's got limited parenting time, even though he should have custody, but the court gave him very limited parenting time. He's got maybe a week more extended time than the mother in this case.
Was that issue raised on the objections from?
I think it was. I'm pretty sure it was. I'm trying to see. I've got one copy of objections here. It's not in this written version, Judge, so. I know we included it in our brief, and his visitation is limited. His parenting time is very limited. For really no reason. The magistrate and the judge approved it. Again, they speculate about a lot of things. Well, he violated a protection order 20 years ago, so he may not keep the child safe. We believe the testimony of the mom that he may have drugs in his home, so we're going to limit all these things. None of this is factually based. It's all based on pure speculation. There is no evidence, much less a preponderance of the evidence, that this man was unsuitable to raise his child. There was no evidence provided. They talk about the child sitting on his lap in the parking lot while he's waiting for a parenting exchange. He's not driving on the street. He's sitting with the son in his lap. The grandmother or the step-grandmother pulls up and sees the child on the lap, and now he's dangerously driving around with the child. I said, from the very beginning, this has been a reach. Anything that the court can find or the magistrate can grab hold to say that this man should not raise his child, they brought it up, they magnified it, and they put it in orders. But when you look at the facts and you look at him and you look at this case history and the history from this court as to what makes a parent unsuitable, Mr. Jones fits none of that criteria.
How old is the child now?
I believe he's 5,
5, okay, thank you.
and Mr. Jones has been visiting with him consistently since he was 1. Paternity took forever to get established. They had no problem. They wouldn't give him parenting time until paternity was established, but they did take a support order back to the child's date of birth, and that's noted in the decision as well. His arrears amount was $16,000 when that was established. And they talk about the support. The support records indicate that he's paid monthly throughout the case. I know my time is up. I do apologize, but we would like
That's
the
okay.
court
If
to
you-
remand and grant father custody of his son. Thank you.
Thank you. Thank you both for your arguments this morning. I mean, obviously, this is a very important case, and I understand that. And I appreciate, both of your positions on this. We're going to take the matter under submission and issue a timely decision. And that concludes the proceedings for today.